Sure. Yeah, we can do that right now.
So this should be fairly short, Your Honor. It's a straightforward motion. I know the court has had a chance to review it. We filed it on Friday, and this addresses the issue of the scope of cross-examination. And obviously this stems from the court's rulings on the efforts to go into some of the legal framework regulations governing the production and importation of active pharmaceutical ingredients for opioid drugs and actually for other drugs in this country, as well as the FDA regulatory framework that governs the way the products that Janssen sold are marketed, are brought to market, are approved by the FDA. And all of these issues are particularly relevant given the testimony we've heard. They're particularly relevant given what Dr. Kolodny testified to on direct. As Your Honor knows, Dr. Kolodny testified that he felt that J&J, by virtue of its ownership of these subsidiaries, Aramco and Tennessee Nationals, was a kingpin supplying to other drug dealers. And cross-examination, under the rules of cross-examination, naturally implicates questions about the legal framework. If you had a case where you had something akin to an actual kingpin, as opposed to the way the term is being used in an inflammatory manner here, and cross-examination was, well, this alleged drug dealer, this alleged kingpin was complying with the law. Here the laws that govern the conduct that would clearly be within the scope of cross-examination of somebody who took the witness stand and said, I think this person was acting as a kingpin. And I think that one way to think about it and sort of bring it back into what we typically see in the courtroom is by analogy. And we previewed this analogy a little bit in our briefing, but let's say we had a witness on the stand who got up and there was a car accident and said, well, I think that the defendant was driving the car recklessly. The defendant was probably going 30 miles an hour. Now, I would be able to get up and cross-examine that witness and to say to that witness, well, you testified that you think my client was going 30 miles an hour. Do you know what the speed limit is on that street? And plaintiff wouldn't be able to raise an objection. Say, Your Honor, my client just testified that 30 miles an hour was reckless on that road. He didn't testify about what the speed limit is, what the law allows you to go there. And so I would be able to ask, do you know what the speed limit is? And if the witness said, no, I have no idea, obviously that impacts the credibility of that witness as to this idea that my client was driving recklessly. Now let's say this person was an expert witness, and this person said, well, I really do think it was reckless, but evidence showed that the Department of Transportation had collected data, had engaged in a study, and undertaken an analysis and decided what is the safe speed on that road, given what we know about the number of turns in the road, number of lights, whether there might be a stadium or a public space in that area, how much traffic there is. I would be able to ask the witness, well, did you look at what the Department of Transportation studied when it was deciding the speed limit on that road was going to be 35 miles an hour? And the witness could say no. But just the answer to that question would not be objectionable. The answer to that question, even if the answer was no, would inform the court, finder of fact in that case, as to the credibility of that witness. And that's exactly what Janssen defendants are seeking to do, or were seeking to do, when Mr. Yoder was questioning Dr. Kolodny on those subjects. And so, based on that, we would ask the court reconsider its ruling sustaining the objection to the questioning about the framework governing the production of the raw materials and the importation of API, as well as the scope of the regulatory framework, including the product development process and the legal regulatory framework governing what Janssen can and cannot say in its marketing, cannot do in its marketing of its prescription drugs. And again, if the answer that Dr. Kalani gives is, well, I'm just not familiar with that, I didn't consider that, that certainly impacts the credibility of his assertion that Johnson & Johnson was acting as a kingpin. Thank you, Your Honor.
Thank you, Mr. Brody. Mr. Beckworth, please respond.
Thank you. We didn't file another brief to this issue because I think it's been briefed a lot, but just real quickly, let me maybe put a few things into context. I think that Johnson & Johnson is, I don't want to say it's in a pejorative way, but it's a little misleading what their argument is compared to what we're actually doing. Number one, let me be clear. On these issues of regulatory matters, I've said this half a dozen times in this court. If this company will stipulate that they will not try to remove this case, and if they'll stipulate they won't argue preemption by their crafting something that's not in our case, then by all means, let's have at it. I don't think they like the answers that we've given. But because they won't do that, we know exactly what this exercise is all about. That's why we haven't made it part of our case. We said from day one of the motions to dismiss hearing that none of this was a part of our case. We've been very smart in how we've presented our witnesses. There's been many motions about this. So they're here, they have the opportunity to make any stipulations they want. I invited them to do that while their corporate rep was here and they declined. So let's just put that over in a bucket. But let's talk about this idea of Noramco for a minute. First, the idea of a kingpin, actual versus inflammatory, as they just said. There's nothing inflammatory about it. The definition of kingpin simply means the chief person in an undertaking. We've established already in this case that their market share argument is just made up. We've shown that in 1994, 2 years prior to OxyContin hitting the market, that Johnson & Johnson met with Purdue. They started creating a specialized strain of poppy to anticipate the demand for the growth of oxycodone in this country. Now, there's no way that could have happened if they weren't working in concert. There's no way. And we saw, as we've shown Your Honor, with a lot of deliberation, a series of agreements that were made. And we see in 1998, the head of Noramco coming back and telling Purdue, look, we've been talking about this for many years. If you want us to supply you, we will, and you have to get a long-term agreement to do it. We saw right after that Purdue saying the only limit to our growth is supply. We've seen that Johnson & Johnson gave a medal to the scientists, and they say in their words, this led to the growth of oxycodone. And it's not an Aramco medal. It's not a Tasmanian Alkaloids medal. It's a Johnson & Johnson medal. And when Johnson & Johnson divested itself of this company, despite what these lawyers have argued about it not really being them, we see in their 10Q filed with the SEC under the penalties of Sarbanes-Oxley that all that money went to the company, and that's Johnson & Johnson. Now, why does that matter here? Well, we must ask ourselves, why does this company that was selling Duragesic always engage in marketing that's about opioids? Why would they do that? Duragesic's an opioid, but it's not the only one. So why would they just market opioids as being safe and effective and not addictive? Why would they do that? It makes no sense unless you understand what they're doing with Noramco. So they started this in opening statement showing a pie, very deceiving. They put a little sliver and said, here's our market share for Duragesic. And then they said, oh, there's just a few examples of addiction worldwide. What they didn't tell you was that market share was about state-paid data only. We don't have a false claims claim in this case. And they didn't talk about all the other opioids that they were behind. Now, how does that all tie into this case, and why does this regulatory matter not matter? We're not challenging the fact that this company was allowed to sell under the DA quota system API, nor are we challenging the fact that they're allowed to sell opioids. That's not what the case is about. But if you're allowed to own a gun, which I own and I'm allowed to do, that doesn't give me a license to go do unlawful things with that gun. If you're allowed to own a car, in this example, it doesn't allow me to run down the street and start mowing people over. So with respect to this issue, you'll see Mr. Machette will play his video here in the next few days. I asked him under oath, this was a supply person and distribution person at J&J, We talked about this code of conduct that Mrs. D. Meshman said was the moral fabric of this, or the entire fabric, whatever, of that company. And within that code of conduct, it says you gotta hold your partners responsible. Well, Mr. Michette, we went through a line of questioning about that. And he said, look, when somebody's doing something wrong and you're in business with them, you have a duty to stand up and stop it if they're acting inappropriately. And I asked him, well, you knew about the GAO report with Purdue, you knew about the criminal conviction with Purdue, yet you were supplying them with oxycodone and you were in a partnership agreement with Ultran, with Purdue. You were partners at the table. Where's the evidence that you ever stood up and said, no, enough is enough? And he said, well, I'm not aware of any. We've tested it in front of the witnesses. They never told Purdue they weren't going to do business with them. They just kept on keeping on. So when you look at this issue with Aramco, it's not about what the DEA allowed Johnson & Johnson to do with supplying API, nor is it about what the FDA allowed them to do with selling a drug that's perfectly legal to sell. It's the manner in which they did it. It's the motive that they had. It's the reason they said opioids and not Duragesic. So I think this is very simple. We have not put this witness on, nor are we going to put anyone else on to talk about the regulatory process and how those laws get passed, what was or wasn't said to get the labels the way they were. That's something that needs to be addressed in this country in another forum, but it's not what's at issue here. So we respectfully ask that the court stay right in line with its prior rulings. We've walked this line very carefully. I think we're absolutely entitled to do it the way we've done it. Thank you.
Thank you. Mr. Brody, would you like to respond?
Yeah, very briefly.
Sure.
I think that Mr. Beckworth didn't offer the court anything on the issue before the court, which is what is the proper scope of cross-examination. We know that fear of federal jurisdiction is not an evidentiary objection. Cross-examination is governed by the scope of the testimony that's offered by a witness, and Oklahoma law makes clear that when issues are raised on direct, those issues and matters relevant to those issues and the credibility of the witness's testimony are properly within the scope of cross-examination, and that's what we have here. We heard a lot of argument on facts from Mr. Beckworth, but those arguments that he made on the facts implicate what the key issue is here. He says the question is the manner in which Janssen and Johnson & Johnson acted. These are his words, the manner in which they did it. Well, the question of this comprehensive regulatory framework goes directly to the manner in which Johnson & Johnson acted, and the question of whether the company acted reasonably, whether the company acted in conformance with determinations that were made by DEA, by FDA, as to, and this is key, what they look at is they go to what supply of active pharmaceutical ingredients, not just for opioids, but for various different medications, are required in order to ensure the health and safety of the citizens of the United States of America. And that is directly relevant in a situation where we have somebody saying, well, you were a kingpin, running a drug dealing enterprise. Mr. Becker tried to say that's not inflammatory. It certainly is extraordinarily inflammatory, and particularly in a situation where you have that overarching framework and where decisions are being made based on what is necessary for the health of the American public, where concerns about disruptions to the supply of the active pharmaceutical ingredients for these, what even Dr. Kalani himself has said are essential medications, is what drives that decision making. There are reports every year from the FDA that speak to steps that have been undertaken to assure that supply, the security of that supply, the purity of that supply, so that we have what we need, so that we don't have medication shortages, something that has been an issue in this country, most recently following the hurricane that went through Puerto Rico and impacted various manufacturing facilities there. So all of this is directly relevant to the credibility of the allegations that are being raised, and more fundamentally, bringing it back down to the issue here, directly within the scope of the direct testimony that's been offered by Dr. Pilotny and by other witnesses, and it is properly within the scope of cross-examination under the Oklahoma rules. Thank you, Your Honor.
Thank you, Mr. Brody. Because I believe the subject matter to which Johnson & Johnson is requested, namely the framework behind the production of the API, the other matters that had been spelled out in both the written and the oral arguments, because I believe those are not relevant and are not in line with the testimony for which Dr. Kolodny was presented. I believe they're in proper scope of cross-examination, and I deny the motion. Okay.
Thank you, Your Honor. We will, at the conclusion of Dr. Pilotny's testimony, submit a written offer of written report.
Okay. Thank you. Thank you. Mr. Yoder, we invite you now to resume the cross-examination. Yes, you may.
Thank you. Good morning, Dr. Pilotny. How are you this morning?
I'm fine, thank you.
We'll finish up here and be done with it, okay?
Sounds good.
I'd like to put up on the screen Court Exhibit 65, if I could, Your Honor. That's the one we were looking at prior.
Yes, you may.
And when we were looking at Court Exhibit 65, Dr. Pilotny, you'll remember this showed what you testified to be the substantial increase in unintentional prescription drug-related deaths in Oklahoma from 94, 96 through 2009, and how Janssen did not market and sell its Nucenta and Nucenta ER products until after this substantial increase had taken place. And it took a while, but eventually you agreed with that. And what I'd like to now, though, look at is Duragesic, the Duragesic brand fentanyl patch. And we can agree that Janssen was marketing and selling its Duragesic brand fentanyl patch during the 1996 to 2009 timeframe, right?
Prior.
Even prior. They started in 91, right?
Correct.
Continued through the end of the 1990s, right?
And beyond.
And beyond. And I think we've already covered that they started to cut back active marketing in 2005 and then ended the active marketing in 2008, at least of the branded Duragesic patch, correct?
Right, of their specific brand.
Right. So, isn't it true, Dr. Kolodny, that Janssen's marketing and sale of its Duragesic brand fentanyl patch also did not cause the substantial increase in unintentional prescription drug overdose deaths in Oklahoma that occurred through 2009?
No.
Isn't it true, Dr. Kolodny, that your opinion, at least prior to the time you became a paid expert for the state, was that had the FDA taken action against Purdue Pharma when it began to market and sell its OxyContin opioid drug in 1996, there would have been no opioid crisis?
Same objection regarding the FDA, Your Honor, and that's just another around the ruling you just made.
This is impeachment, Your Honor.
I sustain the objection.
May I approach, Your Honor?
Yes, you may.
Is it possible to do outside of the presence of the witness?
single trail on the side.
Let me re-ask the question then, if I might, Dr. Kolodny. Isn't it true that the opinion you expressed publicly prior to the time you became a paid expert for the state was that had the FDA taken action against Purdue Pharma, when Purdue Pharma began to market and sell OxyContin in 1996, there would have been no opioid crisis?
I just need to reassert the objection.
Thank you.
I believe what I've stated publicly is that there were actions FDA could have taken early when there was a clear sign that the prescribing was taking off at a rate beyond what could be clinically needed, that there were actions that FDA could have taken that could have helped prevent the epidemic from getting as bad as it did. I don't recall ever saying that FDA could have stopped the problem in its tracks and reversed it. If I did say that, I no longer believe that.
Isn't it true? I don't think you're really answering my question. Isn't it true that before you became a paid expert for the state, when you submitted a statement to Congress, you expressed the opinion that you strongly believed that the public health catastrophe could have been avoided if the FDA had properly enforced the Food, Drug, and Cosmetic Act when Purdue Pharma released OxyContin?
Yes, I believe I stated that at the time.
In 2014, correct?
I believe so.
In a statement that you made to the U.S. Senate Caucus on International Narcotics Control, correct?
Correct.
The 113th Congress, second session, correct?
Correct.
And in addition, in that statement, you also advised the U.S. Senate that your view was that the FDA, instead of enforcing the act, allowed Purdue Pharma to promote OxyContin to family doctors for treatment of common aches and pains and to launch a campaign of misinformation about opioid risks and benefits. True?
True for Johnson & Johnson as well. I'm much more aware now that Johnson & Johnson was doing exactly the same thing that Purdue Pharma was doing.
Your Honor, I move to strike the last comment. That was not my question. It was non-responsive.
Your Honor, that's the same hide-the-ball tactics. They're talking about something they said they're going to, quote, impeach him on that he said before he got involved in this case. And he testified under oath to you that but for you're allowing everyone to see the truth about J&J, no one would have ever known what J&J was.
I'm going to overrule the motion to strike. Proceed to the next question.
And Your Honor, I would make a request, though, that there not be speaking objections.
Sustained.
In your statement to the Senate, you said nothing about Janssen's marketing and sale of its branded Duragesic fentanyl patch, correct?
I really did not know much about Janssen & Janssen's marketing, so at the time I didn't mention anything about Johnson & Johnson's marketing of Duragesic because my familiarity was with Purdue's marketing, as were most people following this closely, because there was a GAO report, there had been a criminal conviction. Everything that Johnson & Johnson had been doing was not publicly known at the time. So yes, my comments were limited to Purdue Pharma.
Not what my question was, Dr. Kolodny. This was in 2014, correct?
That's correct.
You were aware that Johnson & Johnson was a member of the Pain Care Forum by that time, correct?
That's correct.
You were aware of Johnson & Johnson's involvement in some of these societies that you testified to. You testified to it here, correct?
That's correct.
And in 2014, when you made your statement to the U.S. Senate, do you agree that you said nothing about Janssen's marketing and sale of the Duragesic fentanyl patch? Just yes or no, sir.
I believe that I mentioned other, I don't have the testimony in front of me, but I believe that I mentioned other opioid manufacturers. Maybe I didn't, but I believe that I did. I do not recall specifically mentioning Johnson & Johnson or Endo or Insys or any of the other opioid manufacturers that were doing what Purdue Pharma was doing.
Do you dispute? I will represent to you that I have looked through this statement that you provided to the Senate, and it makes no mention of Janssen's marketing and sale of its branded Duragesic fentanyl patch. Do you deny that?
Your Honor, he's asking about a document that now the lawyer says he's read from 5 years ago. I don't know if it's on their exhibit list. So
It's impeachment, Your Honor.
if it's not on your exhibit list, you've clearly been working with your team. It's not on their exhibit list. If he wants to ask Dr. Clyde about it, I think Dr. Clyde should have a fair chance to review it.
Your Honor, the pretrial order specifically excluded impeachment documents as is customary.
I will overrule this objection.
Thank you. May I approach, Your Honor?
Yes, you may.
A3632.
Thank you.
Document. May 14, 2014, America, addiction to opioids, heroin, and prescription drug abuse, U.S. Senate, Caucus on International Narcotics Control, 113th Congress session. And if you look toward the back of the document, Dr. Kolodny,
Yes.
you'll see there's a document entitled Statement for the Record, Andrew Kolodny, MD, Chief Medical Officer, Phoenix House Foundation, President, Physicians for Responsible Opioid Prescribing, before the Senate Caucus on International Narcotics Control, America's Addiction to Opioids, Heroin, and Prescription Drug Abuse, May 14, 2014. And there follow then six pages, correct?
That's correct.
And that represented a statement that you submitted to the Senate Caucus on International Narcotics Control in May of 2014, correct?
Correct.
About 3.5 years before you became a paid expert in this case, correct?
That sounds about right.
Your Honor, I move admission of 3632.
Your Honor, we have no objection to this document coming into evidence, as long as your Honor's okay with it not being on the pretrial record.
I will admit J3632 into the evidence.
So let's take a look at page 1. If we could publish that, Your Honor?
Yes, you can.
And then go to the statement, which is 6 pages from the end, if you would, Janice. And there's a paragraph, second paragraph under the heading Concerns about the U.S. Food and Drug Administration's opioid policies. The reference there is to Purdue Pharma and OxyContin, correct?
In that paragraph, yes, but
That's all I'm asking.
but elsewhere, I know, but elsewhere in this document it says manufacturers,
Sure.
not, so it's not specific to Purdue.
Well, the statement you're making here is that you strongly believe that this public health food catastrophe could have been avoided if the FDA had properly enforced the Federal Food, Drug, and Cosmetic Act, FD&C Act in 1996, when Purdue Pharma released OxyContin. Statement you made to the U.S. Senate, correct?
That's correct.
And then you go on. Instead of enforcing the FD&C Act, FDA allowed Purdue Pharma to promote OxyContin to family doctors for treatment of common aches and pains and to launch a campaign of information about risks and benefits. And in that sentence, what's the company that you mentioned?
In that sentence, I mentioned Purdue Pharma.
Thank you. And that's because, at least prior to the time you became a paid expert in this case, or at least prior to the time Purdue settled, your public position was that the acceleration in opioid use from late 90s through 2009 or 10 was fueled by the introduction of OxyContin by Purdue, correct?
Your Honor, I object on the basis of compound. He asked two questions. One, before he became someone who worked in this case, and the second one was when Purdue settled, and he knows that they deposed him and linked in this case. So that's a compounded proper question.
We did 2 days after the settlement. We deposed Dr. Galati, and we'll get there, but I can break it up here.
Please do.
Thanks. So isn't it true that the reason, we'll strike out, isn't it true that before you became a paid expert in this case, the public position that you took was that the acceleration in opioid use was fueled by the introduction in 1995 of OxyContin by Purdue Pharma?
Mr. Yoder, if you look 2 paragraphs
Sir,
above, I'm answering your question, sir.
No, you're not, please.
The
Your Honor,
witness
I would
is
ask-
allowed to answer the question. You can object afterwards, but let him answer the question.
If you look 2 paragraphs above the paragraph that you highlighted, it states, doctors didn't start over-prescribing opioids out of malicious intent. For most of us, it was a desire to treat pain more compassionately that led to over-prescribing. We were responding to an educational campaign funded by opioid manufacturers that minimized risks, especially the risk of addiction, and exaggerated the benefits of using opioids long-term for common problems. If you look at what I put in parentheses, it says manufacturers. I was referring to more than just Purdue. I comment specifically about Purdue because there's a lot more information available about Purdue's misdeeds. Much more is known than what's known about Johnson & Johnson.
Didn't answer my question, sir, so I'm going to keep trying until I can get a straight answer. Isn't it true that before you became a paid expert in
I
this
object
case?
to that and I'm distracting, Your Honor. If they can't say stuff like that. It's improper.
Mr. Becker, I'll overrule your objection. Mr. Yoder, please state your question.
Isn't it true that before you became a paid expert for the state in this case, you took the public position that the acceleration in the rate of opioid use starting in 1996 was fueled by the introduction in 1995 of OxyContin by Purdue Pharma?
That's mischaracterizing my view. My view is that a multifaceted campaign that promoted opioids as safe and effective for conditions where we probably shouldn't use them, that downplayed their risks, exaggerated their benefits, a multifaceted campaign underwritten by opioid manufacturers.
And I realize that's what you're saying now, here testifying as a paid expert. But isn't it true that before you became a paid expert for the state, you publicly wrote that the rate of opioid use that began to accelerate in 1996 was fueled by the introduction in 1995 of OxyContin by Purdue Pharma? Yes or no?
That's mischaracterizing what I've written and stated, and even in this document that's in front of you. It wasn't simply that Purdue Pharma introduced OxyContin that led to our opioid addiction epidemic. It was the unbranded campaign to increase prescribing of opioids as a class of drug that affected all opioids. And that unbranded campaign, it wasn't just Purdue Pharma behind it. Johnson & Johnson was hand in hand with Purdue in promoting that unbranded campaign.
I know you say that now, but I'm trying to look at the statements you made before you became a paid expert.
It says manufacturers on that, in that statement.
May I approach, Your Honor?
Yes, you may.
I'm going to hand you Exhibit S 3138, which I believe is already in evidence. If we can publish it, Your Honor.
Yes, you may.
So I believe counsel asked you about this. This is an article that you co-authored with, among others, Dr. Courtwright, correct?
That's correct.
And this article was published, it appears in 2015, correct?
It was published in 2015, that's correct.
So if we, and the title, because the prescription opioid and heroin crisis, a public health approach to an epidemic of addiction. That's the title of the article, correct?
It is.
So you're addressing the opioid crisis, what you've been testifying to here in court, correct?
Yes.
Okay, take a look at page 5. There's a heading there, the sharp rise in prescription opioid consumption. And I want to start in the first paragraph, the second to last sentence. It starts out in 1996. The rate of opioid use began accelerating rapidly. This acceleration was fueled in large part by the introduction in 1995 of Oxycontin, an extended release formulation of oxycodone manufactured by Purdue Pharma. It's a statement you made in this article, correct?
Correct.
Okay, let's keep reading. It goes on in the next paragraph to talk about between 1996 and 2002, Purdue Pharma funded more than 20,000 pain-related educational programs through direct sponsorship or financial grants and launched a multifaceted campaign to encourage long-term use of OPRs for chronic non-cancer pain. Again, what you wrote in your 2015 article, correct?
That's right. And
That's all I'm asking you, sir. Please, stay with me so we can go through. And then if we go down to the next paragraph, talks about the fifth vital sign that you talked about, correct?
That's correct.
And as I'm looking through the rest of this section, you agree, you say nothing about Janssen's marketing and sale of its Duragesic branded fentanyl patch. Not asking about this multifaceted campaign that you've testified to. I'm focusing right now, doctor, on Janssen's marketing and sale of its Duragesic branded fentanyl patch. Would you agree there's no mention of that in this article?
Your Honor, again, I object. You cut the witness off the prior question. All you have to do is look at the entirety of this page to see that this entire line of question is completely misleading and untrue.
Your Honor, there's nothing misleading.
I'll overrule the objection, and no, Mr. Beckworth, you'll have an opportunity for a redirect.
Is there an answer to that question? So, would you agree, Dr. Kolodny, that you make no specific mention of Janssen and its marketing and sale of its branded Duragesic fentanyl patch in this article?
The article does not, there's only one opioid mentioned, it's OxyContin. It does not mention Duragesic.
Thank you. And even more recently, in June of 2017, but again before you became a paid expert in this case, isn't it true that you were a panelist at a Washington Post live event where once again you expressed the view that there would not be an epidemic today if the FDA had properly enforced the law against Purdue and OxyContin. Do you remember that?
I remember that event, and what I believe I said, although, to know for certain I'd have to review a transcript or see a video, but what I believe I said is that the epidemic, had FDA responded appropriately in the early 2000s, it would not have gotten nearly as bad as it did.
Did you make the statement in that presentation, doctor, that had the FDA properly enforced the law against Purdue Pharma when it released OxyContin, you did not believe there would be an epidemic today?
I think that I probably said two things, and
I'm just
maybe
asking you
so.
about it right now.
Right. So I do think that I said that if FDA had started to respond appropriately in the early 2000s, we could have prevented the epidemic from getting nearly as bad as it did. But I do believe that I said there and have said elsewhere that had FDA strictly enforced the Food, Drug, and Cosmetic Act when Purdue Pharma had introduced OxyContin, had they limited Purdue Pharma to promoting OxyContin in hospice and palliative care settings, that we might not have an epidemic today. And certainly the same could have been said for Johnson & Johnson.
Still not answering my question, so let me try again, okay? And if you can answer my question directly, I'd appreciate it, doctor, okay? Isn't it true that in the presentation that you made, the Washington Post, you took the position that had the FDA enforced the law against Purdue Pharma when it released OxyContin, you didn't believe there would be an opioid epidemic today?
That's not exactly what I said. What I said was that had FDA strictly enforced the law when Purdue was going to introduce OxyContin and had limited OxyContin's promotion, Purdue Pharma's promotion of OxyContin, we might not have an epidemic today. That is what I think I said.
May I approach your
Yes, you may.
I am told that we may have mismarked that prior exhibit. It should be 3932, and then this will be 3932.
So to be clear, the Homeland Security Committee report is 3932, not 3632.
Yes, sir. Madam Clerk?
Yes.
So I have handed you the document, login that was marked as exhibit 3933. It's a transcript edition in America, Washington Post blog, June 22, 2017. And this was a panel that you participated on, correct?
Correct.
Along with Senator Ed Markey, correct?
I don't think he was on the specific panel with me. I think he was also at the event, though.
Congresswoman Diana DeGette.
She was at the event, but I was on a panel with Dr. Wen.
So you were on one of the panels at this event, correct?
Correct.
And this is a transcription of that panel?
Yes, it is.
Your Honor, I move exhibit 3933 into evidence.
For what purpose?
For impeachment, Your Honor. He denied making the statement. The statement was in his document.
Did you deny making a statement? I don't think that's what happened at all. Your Honor,
I think it is, Your Honor. He said that no, he did not make a statement in that fashion. I have exact words if necessary, but he denied that he made the statement as I described it, which comes from this particular document.
So again, Your Honor, I don't know how to argue an objection without talking, so I was objecting to making a speaking objection. But the defendant has worked as part of the joint defense agreement, not only here but nationally. This is a key witness in the case. They've known about everything he said for a long time. I don't have a problem at all with using stuff that's not on their exhibit list as long as we get to play by those same rules. That's what I've maintained all along. I'm trying to keep with what Your Honor's admonitions were prior to the time the trial began. But if we can do the same with their witnesses, and we can just do anything we want when it's not on the exhibit list, we wouldn't have an objection. I just want to make sure that it's paired.
I certainly am not going to allow for either party to bring in exhibits for any purpose. As I stated earlier, I intend to only allow exhibits that were listed in the pretrial conference report unless there is some good cause shown. I asked Mr. Yoder what the purpose of this document is. He's indicated it's for impeachment purposes based upon the questions that have been asked by to Dr. Kolodny and the responses and the statement made by Mr. Yoder. I will admit 3933 for the limited purpose of impeachment only.
Thank you.
Thank you. So if we could just put the first page up. And you'll see this is the transcript from this panel Addiction in America conference, June 22, 2017. And then if we could go to page 14 of 33. You're quoted there following a question by, is it Mr. Bernstein or Ms. Bernstein?
Mr. Bernstein.
Mr. Bernstein, about 2/3 of the way down. You start out and you ask Andrew or doctors getting the message, you say, I'm not so sure. The increase in opioid prescribing that would ultimately lead to this epidemic, it starts in 1996. And then if you go down to the next paragraph, and I think one of the problems has really been the Food and Drug Administration. I think that unfortunately, the Food and Drug Administration is not properly enforcing the Food, Drug, and Cosmetic Act. Had it been properly enforcing that law back in 96 when Oxycontin was the FDA would have told Purdue, great, you have extended release oxycodone, you can market that drug for use, hospices, you can send your sales reps to the palliative care doctors, to the hospices, but we're not going to let you promote Oxycontin for back pain. We're not going to let you do this in primary care and family practice because the risks of using opioids for back pain outweigh the benefits. And then you conclude in the next paragraph, and so if they had properly enforced the law, they would have done that, and I don't think we have an epidemic today. That's what you stated in this panel discussion, correct?
That's correct.
Now, you also made reference in this panel discussion to endo. Remember that?
I don't remember.
Look at the next page, page 15. Where again, you're responding to a question by Mr. Bernstein, and you make specific reference to endo pharmaceuticals, correct?
Yes?
Did you make any reference in this June 2017 panel discussion of Janssen and its marketing and sale of its Duragesic fentanyl patch, branded Duragesic fentanyl patch?
So I'd have to go through the whole transcript, but I think it's very likely I talked about the role of opioid manufacturers. I may have only mentioned Purdue and Endo by name. I probably did not mention Johnson & Johnson by name, and until this litigation, I was not that aware of Johnson & Johnson's wrongdoing.
It's not my question, sir, and I move to strike the last part as non-responsive here.
I already answered the question.
I overrule the motion or the request.
I'll tell you this, Dr. Plotty. If you want to find some reference, I'm asking specifically about Janssen's marketing and sale of its branded Duragesic fentanyl patch. And would you agree that you said nothing about that in this panel discussion?
Yeah. If you read my comments in the discussion, you'll find that what I really cite as having caused and fueled our opioid epidemic was an unbranded campaign.
Okay, so
I mentioned here endo as an example of a drug that had been removed from the market. But when I talk about the campaign to increase prescribing, I generally talk about the role that opioid manufacturers play. When I speak about a specific manufacturer, I generally cite Purdue because that's what we have had most of the available information on, has been Purdue's role.
You're not answering that question, sir. We will get to unbranded, I promise you. Okay? We're talking about marketing and sale of branded product. And right now we're talking about Janssen's branded product, the Duragesic fentanyl patch. That's all I'm asking you about. I'm not asking you to talk about your multifaceted campaign theory. So would you agree with me that you make no mention in this panel discussion of Janssen's marketing and sale of its branded Duragesic fentanyl patch?
The question you're asking, no or yes answer is misleading, because what I'm really focused on and what I have been for many years has been an unbranded campaign. I also don't speak much about the specific misbranding of Purdue Pharma, the way they promoted OxyContin as less addictive because of its extended release formulation. That's not something I generally talk about. What I generally talk about is the unbranded campaign that changed the culture of opioid prescribing, and I talk about the role of opioid manufacturers. So to just say no is somewhat misleading when branded promotion is not really what I was focused on here.
It's for the court, not you, to decide what's misleading or not, Doctor, and I really would ask you to answer my question. Would you agree that in this panel discussion, as in the other documents we've looked at, you made no mention of Janssen's marketing and sale of its branded Duragesic fentanyl patch? Yes or no?
Yes, I did not discuss Duragesic.
Thank you. And indeed, we've been through thousands of public statements you've made in articles, in interviews, in tweets that you've made up through 2017, and have not seen any mention in any of those of Janssen's marketing and sale of its branded Duragesic fentanyl patch. Can you identify any such statement that you made prior to being retained as a paid expert in this case?
I don't recall discussing specific opioids, except maybe when a drug was getting newly approved. Maybe on occasion I would talk about OxyContin, but my public comments have generally been about the promotion of opioids as a class of drug, and I knew very little about the direct marketing of Duragesic before I was working on this case.
Again, you're not answering my question. If you could, please. Can you identify any specific public statement you made prior to the time you were retained as a paid consultant and expert in this case, where you raised issues specifically about Janssen's marketing and sale of its branded Duragesic fentanyl patch?
Objection, asked and answered. The attorney asked about thousands of the attorney had been through. Dr. Plotty said, I don't recall maybe. And he gave an explanation. I think the question has been answered.
I don't think I've gotten a straight answer here.
I think Dr. Kolodny has answered, and I will sustain the objection.
So let's move on to unbranded then, Doctor, okay? You had referenced in some prior testimony here that you were under the impression that with respect to Janssen's launch of Nucenta and Nucenta ER, you thought there was some unbranded marketing that preceded. Did I understand that correctly?
Uh, Yes, I've reviewed documents that indicate that Johnson & Johnson, prior to the approval of tapentadol, before it had hit the market, and before they were allowed to directly promote, that in the lead-up, they had an unbranded campaign.
And tapentadol is the active pharmaceutical ingredient in both Nucynta and Nucynta ER, correct?
That's correct.
I think one of the documents that Mr. Beckworth went over with you on this topic was States Exhibit 1780. We could pull that up. May I approach, Your Honor?
You may. Thank you.
Thank you.
So, you remember going over this document with Mr. Beckworth?
I believe so.
And you understood this to be an internal planning document with respect to the planning for the launch of Nucynta and Nucynta ER, correct?
Correct.
It says on the first page, Tapentadol, IR, ER, that's really the label of the active pharmaceutical ingredient for Nucynta IR and Nucynta ER, right?
That's correct.
So it wasn't really clear to me, based on Mr. Beckworth's questioning, if you know when this document was actually prepared.
I don't know for certain when it was prepared. Because it's a 2008 strategic plan. In my experience reviewing business plans, strategic plans that have a year on them, they're typically done the year prior. And so I believe that a 2008 strategic plan is drafted in 2007. That's my guess.
Do you know for certain?
No, I don't.
But your understanding of this plan is that it was a planning document describing what was intended to be done at some point in the future.
Right.
And in this case, that future would be 2008.
Correct.
So let's take a look at page 15, if you would. And you'll see here that it calls for an unbranded campaign to start sometime after January 2008. Do you see that?
That's correct.
And do you have any evidence that there was, that this unbranded campaign began prior to January 2008? Do you have any reason to question this document that you testified about?
I'm not sure I understand your question. Do I have reason, are you asking, do I have reason to believe that there was not an unbranded campaign before 08?
No, just this document, you agree, sets forth a plan for an unbranded campaign starting sometime after January 2008, correct?
That's what this document appears to be.
And I'm just asking, do you have reason to dispute that?
Reason to dispute that that's not what this document is?
That the unbranded campaign started sometime after January 2008.
Well, I know that there was an unbranded campaign before 2008.
I'm asking about that involved with Nucynta and Nucynta ER. This is the document you testified to, right?
Unbranded campaigns are generally not about a particular molecule. They're generally about opioids as a class of drug. And so I do know that prior to January 2008, Johnson & Johnson was involved in an unbranded campaign to increase prescribing of opioids. Opioids they were selling to other drug companies.
This is the one that you specifically testified to, so I'd like to ask you about this one first, okay?
Okay.
And if I understood your testimony, you said that when this document, Exhibit S-1780, was drafted, there was already a sharp increase in opioid prescribing in the United States, and it was clear that we were experiencing an epidemic of overdose deaths. You recall that testimony?
I believe I do.
So if we could look at State Exhibit 1223. Am I approaching, Your Honor?
Yes, you may.
Thank you.
And if you can take a look at page 13, sorry, page 12, that's the CDC chart that we looked at before, that you testified shows a substantial increase from 1999 up through 2008, 2009, correct?
A substantial increase in prescribing, deaths, and in treatment admissions for opioid addiction.
OPR stood for what?
Opioid pain reliever.
So opioid pain reliever deaths had, as you testified, substantially increased during that time period, correct?
That's correct.
And then take a look at Exhibit S 2400. This is also in evidence, if I may approach now.
Yes. Thank you.
Thank you.
You learned in your work on this case that the unbranded marketing that Janssen did specifically for the Nucynta and Nucynta ER launch was called Neo Pathways. Did I understand your testimony on that correctly?
There was a Neo Pathways unbranded campaign, but in general, you don't have an unbranded campaign with regard to a specific opioid. By unbranded, that means really opioids as a class of drug, and so unbranded promotion of opioids was something that Johnson & Johnson was doing outside of any specific Neo Pathways special program it had.
I'm trying to focus in on the Neo Pathways. Maybe go back to Exhibit 17. And on page 15. You testified to this document and in particular this page, correct?
Yes.
And your testimony was in part about this unbranded campaign that is shown here starting sometime after January 2008, leading up to a launch of Nucynta in March of 2009, correct?
Correct, but by definition, unbranded really means that it's not going to be about a specific molecule.
I understand, but this unbranded campaign was part of this planning leading up to the launch of Nucynta, right?
Yes.
That's how it's described.
Yes, it looks like leading up to the release of Nucynta, Johnson & Johnson wanted to lay some groundwork through an unbranded campaign that would help boost sales when Nucynta hit the market.
And your understanding is that campaign was called Neo Pathways, right?
Correct.
Okay, so let's go back to Exhibit 2400, S2400. And if you look at page 14, again, this is one of the charts you described as showing a substantial increase in this case, unintentional opioid-related overdose deaths in Oklahoma between 2000 and, for purposes of what we're talking about now, 2008, 2009, correct?
Correct.
So, would you agree that the Neo Pathways unbranded marketing campaign that preceded the launch of Nucynta, the campaign that started sometime after January 2008, did not cause the substantial increase in unintentional opioid deaths in Oklahoma up through the year 2007?
Your Honor, I object to that as misleading. The witnesses testified.
Your Honor, may we approach your Honor?
Yes.
I'm in the middle of speaking.
I think it's improper for counsel to be characterizing the witness's testimony in a way that potentially could suggest an answer to the witness. I think.
Come on up.
Thank you. May we excuse the witness?
Yep.
Thank you.
Yes, go ahead.
this, Dr. Flatt, would you agree that the Neo Pathways unbranded marketing campaign that started sometime after January 2008, preceding the launch of Nucynta, did not cause a substantial increase in unintentional opioid deaths in Oklahoma up through the year 2008?
I would agree that something that starts at a particular point in time can't have an effect prior to that point in time.
Including this, right?
I mean, the question, again, doesn't make that much sense to me because unbranded is unbranded, and whether they put a name like Neo Pathways on it at some point, it was all basically still the same thing and started well before 2008.
Let's deal with specifics instead of the generalities, okay? So specifically Neo Pathways, you would agree, starting in January 2008, it couldn't have caused a substantial increase in unintentional opioid deaths in Oklahoma before then, right?
The term Neo Pathways appears in a strategic planning document, but the activities that are described in Neo Pathways were activities that Johnson & Johnson was engaged in prior to 2008.
Well, let's look at some of those activities besides Neo Pathways, okay?
Okay.
Let's look at finding relief, exhibit S1247. I may approach, Your Honor?
Yes, you may. I do. I've asked Jamie to look into it. Just a second. Thank you. Do you know what's going on with this? Go ahead.
Okay, so this is a brochure that you spent some time testifying about, correct?
Correct.
You consider this to be unbranded marketing, correct?
I do.
And when was this Finding Relief brochure published? When was it issued to?
The publication date appearing on page 2 is 2009.
Okay, let me hand you another document. This is the prescribed responsibly. If I may approach you.
Yes, you may.
This is exhibit J2438. This is another unbranded marketing material that you talked about in your testimony, correct?
I believe so.
And if you take a look at the last page, when was this launched?
The date on the last page of this document is December 2010.
And Your Honor, we have a court exhibit just summarizing those dates, which we would ask to be marked and shown as court exhibit 67.
May I see it? So long as the state has an opportunity to view it first and register any objections.
No objection, Your Honor. Can you publish it?
Yes.
Thank you.
This will be marked states or court exhibit 67.
So at least as to these specific items that you testified to in your direct, the unmarketing campaign that was referenced in that planning document, the Finding Relief brochure that you spent time on, and the prescribed responsibility website that you spent some time on, you would agree that none of those particular unbranded marketing materials caused the substantial increase in the unintentional prescription drug-related overdose deaths in Oklahoma, at least up through 2007, correct?
I would agree that deceptive materials released in 2009, for example, couldn't have an impact on prescribing behavior prior to 2009 if they're released in 2009.
We'll get to finding relief and we'll talk about it. But I'm just asking the basic question. And I appreciate if you can answer that and not try to argue or characterize it. I'm asking about 3 specific unbranded marketing materials. Maybe others, maybe you want to talk about later, that's fine. But at least as to 3, would you agree, without putting labels on your view that they're deceptive, we'll get to that. Would you agree that these 3 unbranded marketing materials, these particular materials that you testified about, didn't cause the substantial increase in unintentional prescription drug-related overdose deaths in Oklahoma up through the end of 2007?
So I wouldn't characterize the 2008 NEO pathways as a specific material. I believe that was the term for a campaign that included different materials. But in general, I do believe that actions that Johnson & Johnson took in 2008 or later would not have caused something that occurred before 2008.
Including these 3, right?
Yes.
Okay. So let's now go back to finding relief. That's the brochure that we spent some time talking about, finding relief, pain management for older adults. Could you pull that out?
I have it.
You testified that the publication date on this was 2009, correct?
That's correct.
Now, we took a look at this earlier, and I don't know, Janice, if we had that slide or not, where you were testifying about the myths and facts on page 10, and we compared that language with the language from the FDA document. So we covered that, but what I want to do now is go beyond the statement that you challenged as having been false, where we looked at the FDA having made essentially the same statement. But you were critical, too, of this brochure, if I understood your testimony correctly, because you thought it was, I don't know whether the term is advocating or promoting quality of life based on the taking of prescription opioids.
Yeah, so when I believe that had this material been branded, for example, with Nucynta, I believe that Johnson & Johnson would have gotten into trouble with FDA because if you'll recall the Life Uninterrupted campaign where Johnson & Johnson promoted opioids as improving function, suggesting FDA didn't even like the photographs that were used that could imply that function is improved. So Johnson & Johnson I'm answering the question, sir. Johnson & Johnson got into trouble for suggesting with a branded campaign that opioids could improve function because as FDA responded, well-controlled, adequate studies showing that long-term use of opioids improve function don't exist.
Sir,
So
we're talking about unbranded.
I understand. So my point is that there are statements in here that FDA would consider deceptive had this been branded.
And one was the picture of the man golfing on the front page. You specifically mentioned that, correct?
Yes, that's part of it, but really it was more the language in this document suggesting here that used properly, opioid medications can make it possible for people with chronic pain to return to some activities, get back to work, walk, run, play sports, and participate in other activities. Adequate and well-controlled studies showing that chronic long-term use of opioids helps people do that, they don't exist. That's deceptive.
Well, I know that's what you testified to. talked about studies that go the other way. But let's focus on this brochure. This brochure doesn't just discuss prescription opioids, does it?
It does discuss other medications. For example, it discusses NSAIDs.
Yeah, look at the table of contents, sir. And you'll see there's 15 separate sections or chapters to this brochure. You agree with that?
Yes, it does discuss non-pharmacologic approaches to treating pain.
And many of those chapters are dedicated to various treatment options besides prescription opioids, right?
There are non-pharmacologic approaches discussed in this document.
So if you look at page 10, start on page 9, medications for pain relief. Talks about aspirin, right?
It does.
Talks about acetaminophen.
It does.
On the next page, it talks about topical anesthetics, correct?
Yes.
If you look at page 11, it talks about other types of medications that can help relieve pain, including antidepressants, stimulants, and anxiolytics. Is that how you pronounce that?
Anxiolytics.
Anxiolytics. So those are all discussed as well, correct?
Correct.
And if you turn to page 12, I think you mentioned this, it also talks about injection therapies, right? Page 12. So again, talks about injection therapies, right?
Correct.
And discusses how they might be used to treat painful conditions in many areas of the body, right?
Yes.
Talks about how injection therapies can be used for both acute and chronic pain, right?
I believe so.
Also talks about physical therapy, correct?
Yes, it's mentioned.
This brochure doesn't make any particular recommendations for any treatment option over any other, does it?
It discusses different treatment options with regard to the medication section. In the NSAID, nonsteroidal anti-inflammatory medication treatment section, I think it heightens risk concerns.
You're not answering my question.
I am answering your question. And with regard to opioids, it dramatically downplays risks in a deceptive way. So in doing that, I believe it's promoting opioid use by scaring patients from taking NSAIDs and making opioids sound completely benign.
Look at page 4 of the introduction to the brochure, including the last paragraph. In this introduction, what it's telling the reader is the brochure and DVD are aimed specifically at older adults and what they need to know to get effective pain relief. You will learn about your options for pain management and how to talk to your doctor about finding a treatment that's right for you. By learning more about pain and the many ways it can be treated, you are taking solid steps toward reducing the pain you or a loved one may be feeling. Now, you testified that you think on that page you wouldn't write it that way, you think it's misleading, but that wasn't my question. My question is, does this brochure make any recommendation favoring one treatment over any other?
There is bias in this document. Does the document explicitly state use opioids for every possible pain condition and they'll never, and that's the best approach for any kind of pain that you can experience? No, the document doesn't say that. The bias is more subtle.
One of the criticisms you had dealt with a golfer, the man on the cover playing golf. And is there anything on the cover that says this man is undergoing treatment with prescription opioids? Yes or no, doctor?
On the Life Uninterrupted
I'm asking
materials
about
that had
this document.
similar photographs,
Doctor,
those,
I'm asking about this document.
so
Please try to answer my question.
you have a, okay, ask the question again, please.
I'm just asking about this brochure. Please don't answer by pointing to another brochure.
Okay.
In this brochure, is there anything on the front cover that says that the man playing golf is being treated with prescription opioids?
In my opinion, in a document that has biased and deceptive information about opioids and states within the document that opioids can help you go back to playing sports, and then on the cover of the document you have a man playing sports, I believe that this document suggests that opioids, being on opioids chronically, allow you to go out and play golf. And I believe that if this had been branded materials, this had been a branded material, that Johnson & Johnson would have gotten into trouble with FDA like it had in the past.
Look at page 15, sir. This is a page where it actually provides some tips for managing pain to the reader, correct?
That's what it says.
And among other things, it encourages the reader to exercise regularly, correct?
It does.
But you're saying, no, the reader is going to conclude that, well, if I take prescription opioids, I can play golf, not if I exercise regularly. That's your conclusion, right?
I'm not sure I understand your question.
That's it. Let's move on. Another discussion you had with Mr. Beckworth involved start with, stay with. Do you recall that discussion?
I do.
And he asked you whether start with, stay with should be part of a company's promotional effort for prescription opioids for non-cancer pain. Do you recall that?
I think so.
And do you recall Mr. Beckworth representing that Janssen was still actually using start with and stay with opioids on its website?
I recall that.
May I want to show you the website. I want to run through it if we could, Your Honor. It's the same
Yeah,
website
yes.
you brought up with Mr. Stone. So if we go to www.janssen.com US HEP-resources, that's the page that Mr. Beckworth brought up. And he clicked on looking for resources to help your patients start and stay on the Janssen medications you prescribe. Contact Johnson CarePath. So let's click on that. And it says Johnson CarePath is one source for resources focused on access, affordability, and treatment support for your patients. You see that?
I do.
And then I think there's a click for johnsoncarepath.com that we clicked on, Mr. Beckworth clicked on, so let's click on that. Well, actually, can we go back one? And under that, it talks about what these resources are. Benefits, investigation support, insurance coverage review, coding and billing information, help identifying financial assistance options for eligible patients, and care coordination. That's the description of these resources, right?
That's what it says.
So we're on the Janssen website. We've clicked on the links that in the examination of Mr. Stone were clicked on. We've looked at these resources dealing with insurance coverage, billing information, care coordination. So let's click on the JanssenCarePath.com. And here is a listing of the product portfolio for Janssen that is covered by this resource guide. And are any of those opioids, doctor?
do not believe any of the medications listed there are opioids.
Thank you. Your Honor, would be a good time for a break?
Be a great time for a break.
Great.
We'll start back up at 10.
Thank you, Your Honor. So, Dr. Kolodny, I want to turn to your testimony about funding that was provided by Johnson & Johnson and Janssen to key opinion leaders and others for consulting work, speaking engagements, and other activities. And you testified, I believe, to a document S-1350. So let me hand you that if you like. Can I approach you on it?
Yes. Thank you.
Thank you.
So you're familiar with that document, correct?
I believe so.
And you'll see at the first, if I may publish it.
Yes, you may.
The payment indicates that it's information that reflects payments by J&J or Janssen to specified individuals, and then it lists the name of the individual, the specialty, the activity, and then payment information. And did you review this document in the course of arriving at your opinions in this case?
I believe I did. I'm familiar with the data on this document.
Pardon?
I am familiar with some of the data on this document.
And in reaching at least some of your opinions, did you assume that these payments that are indicated on Exhibit S-1350 were actually made as indicated?
I would assume that what's listed here would indicate that a payment had been made.
So in the course of the work that you've done in this case, were you able to identify any specific payments made by Johnson & Johnson or Janssen to any of these particular individuals that aren't reflected on Exhibit S-1350?
Are you asking whether or not I'm familiar with documents indicating payments to key opinion leaders not on this list?
Correct.
I doubt that this is a complete list. I think I have seen spreadsheets with many names on it of speakers, so I think I have seen other materials indicating that there are more than these folks. That were, yes.
As to these folks, though, that are on Exhibit S-1350, in the course of your work, did you identify any documents that indicated that they had received payment beyond those reflected on Exhibit S-1350? Do you understand the question?
I think you're asking me whether or not the individuals listed on this document, whether I'm aware that they might have received money beyond what's listed here?
Not mine. Whether you actually saw documents that indicated they did.
I mean, I have seen documents indicating payments to some of to professional organizations that these individuals played a leadership, that some of these individuals played a leadership role in, and I would imagine that that money may have covered their travel expenses or other types of payments. So,
I
yeah.
don't want you to speculate, and I'm not asking about the organizations right now. I'm just asking whether in the work you've done in this case, did you identify any documents showing that there were additional payments to these specific KOLs that aren't reflected on Exhibit S-1350?
I can't recall any documents indicating direct payments to these specific individuals. I can't recall any at this point in time.
Okay. So let's turn to page 5, if you would. And you'll see that one of the names there is Russell.
That's correct.
So I'd like to show you an article written by Dr. Portnoy, Exhibit S0908. And if I understand your testimony, one of your concerns about payments that are made by pharmaceutical companies to key opinion leaders is that it could have an influence on their opinions. Did I understand that correctly?
I can explain. I think that for some key opinion leaders, opioid manufacturers were paying them because they said things that helped opioid manufacturers sell more opioids. And in other cases, key opinion leaders may have just been saying things because they knew that that's what drug companies wanted them to say. In both cases, I think that had it not been in their financial interest, in the financial interest of key opinion leaders, to keep saying these things when it was clear that they were fueling a public health crisis and that pain patients, the very patients that they claimed to be advocating for, were being harmed. I think had it not been in their financial interest to keep saying these things, I think they would have stopped sooner. I think it's very easy to fool yourself when it's profitable to fool yourself.
Let's look at the article, okay? And if you could try answering my questions. Do you believe that key opinion leaders should not accept funding from pharmaceutical companies?
I don't, so I have no problem with physicians working for pharmaceutical companies, and I don't think I don't have a problem with physicians receiving research grants from pharmaceutical companies. I don't believe that doctors who do education for other physicians should take money from drug companies. I don't believe that physicians should be helping drug companies market their products.
Take a look at Dr. Portnoy's information, if you would, and you'll see that the first payment that's listed is in what year?
The first payment from Johnson & Johnson on this document appears to be 1998.
And if you look at Exhibit S908, this is an article from Dr. Portnoy, correct?
That's correct.
And what's the year of this article?
I believe this is a 1986 article, yes.
So 12 years before the first payment that's listed on Exhibit S1350.
That's correct.
And the article by Dr. Portnoy is entitled Chronic Use of Opioid Analgesics in Non-Malignant Pain, Report of 38 Cases, correct?
That's correct.
And if you look at page 8, in the discussion, it starts out, the survey suggests that opioid maintenance therapy initiated for the treatment of chronic, non-malignant pain can be safely and often effectively continued for long periods of time. See that?
That's what it says.
So that was an opinion that Dr. Portnoy expressed 12 years before the first payment that's listed on Exhibit S1350, correct?
That's correct.
You were at Dr. Portnoy's deposition, right?
Yes, I was.
And at his deposition, did you hear him give the following testimony when he was asked if he received money from opioid manufacturers? He testified it never influenced anything he said with respect to something he didn't believe was accurate. Did you hear that testimony?
I recall him saying something like that, yes.
So take a look, if you would, at Exhibit S1350. And another one of the doctors that you have mentioned in your testimony is Dr. Fishman, correct?
I believe so.
So take a look at S1350-2. That shows Dr. Fishman, correct?
That's correct.
And what's the first listed year payments were made for work done by Dr. Fishman?
2008.
Let me show you a document. It's been marked as State 1367. May I approach, Your Honor?
You may.
You'll see this is the curriculum vitae for Dr. Fishman. And if you take a look at page 32, item 24 down at the bottom, you'll see there's an article by Dr. Fishman and others, the opioid contract in the management of patients on chronic opioid therapies in the Journal of Pain and Symptom Management. And what was the year of that publication?
1999.
So that's 9 years before the first payments listed to Dr. Fishman on Exhibit S1350, correct?
Correct.
In the course of the work that you did in this case, did you attend Dr. Fishman's deposition?
No, I did not.
In the work that you've done in this case, did you either watch the video of his deposition or read his transcript?
I believe I've read portions of his transcript.
And when you read the transcript, did you see his testimony where he testified that he would have controlled the content of any publications, lectures, or materials that he authored, and that he did so free from influence of any pharmaceutical companies? Did you read that testimony?
I can't recall.
You also mentioned Dr. Terry Fine. He's on that same page. And what was the year first payments were made to Dr. Fine for work that he did?
The direct payment from Johnson & Johnson, according to this table, would be 2007.
So let me hand you another document that's been marked as State 4702. May I approach you?
Yes, you may.
Thank you.
So this is the CV for Dr. Fine, and if you take a look at page 13, item 49, you'll see there's an article listed 2001 opioid analgesics in older people, clinics in geriatric medicine. And what was the date of that publication?
2001.
And that's 6 years before the first payments for the work Dr. Fine did is listed on Exhibit S1350.
The first direct payments, according to this document.
Then Another doctor that you mentioned that's on this list is Dr. Webster.
Yes.
And on that, it indicates there's no direct payments to Dr. Webster, but there were payments made to his Lifetree Clinic research facility. And are those the kinds of indirect payments that you've been referencing?
No, when I refer to indirect payments, I'm referring to the money that key opinion leaders might get from pain organizations, indirectly from the opioid manufacturers that give money to the pain organizations.
Okay, well, let's look at Dr. Webster then. The first payments to the Lifetree Clinic research facility were in what year?
According to this document, 2010, I have reason to believe that there were financial relationships with Dr. Webster's clinic prior to that date. My understanding is that his pain clinic was frequently visited by sales reps from opioid manufacturers, and and lunches and dinners were involved, and that I don't believe would be listed here. I think this table lists, again, direct payments to these individuals.
And I'm sure if you have evidence of that, Dr. Plotkin, you'll probably provide it to the court. Let's ask about what we have in front of us, okay?
Okay.
And that is 2010. And I'd like to show you a document that's been marked as S-1258. Any approach, Ron?
Yes, you may.
And this is the CV for Dr. Webster. And if you'll turn to S-1258. Item 12 is an article by Dr. Webster. Questionnaire helps screen patients at risk for, look at item 11.
What page?
It's on page 6. I apologize, Your Honor. Item 11. And item number 12, both by Dr. Webster. 11 is predicting aberrant behaviors in opioid-treated patients, preliminary validation of the opioid risk tool, which was in Pain Medicine. What's the year of that publication?
2005.
And then item 12, also by Dr. Webster, questionnaire helps screen patients at risk for opioid abuse in Pain Medicine News. And what's the date of that publication?
2005.
So that's 5 years before the first listed payments on Exhibit S-1350, correct?
Before the payments that are listed here, but I did just remember that there's another financial relationship with Johnson & Johnson, because I do believe that what's not reflected on this document would be payments from CME programs. In other words, when Johnson & Johnson sponsored a CME event, that money would go to the medical education company, and then the medical education company pays the speaker. So that we don't see here. I believe this is, again, direct payments, and many of these key opinion leaders, and the reason that these CVs are so heavy is because they were doing lots of speaking at events that were funded by opioid manufacturers.
My question was pretty simple. Really, it was just, that is 5 years before the first payments listed on State Exhibit 1350, correct?
In terms of the payments that are captured on this particular document, that's correct.
On the State's exhibit, right?
On this specific exhibit, that's correct.
And it's the State's exhibit, right?
It is the state's exhibit.
Okay. And I'm sure if you have evidence beyond that, you'll present it to the court. Let's look at the amounts.
Your Honor, just for the record, this is the defendant's interrogatory. I think it's improper for them to ask the witness about providing more information than they provided in the interrogatory to the court. So I object, that's misleading.
This is their exhibit that they've used, Your Honor, throughout this case. That's the only point that we're doing it.
It is our exhibit. It's what they gave us in lieu of testimony on their contributions. So I think the record needs to be clear about what that is.
I'll overrule the objection. Thank you.
Thank you. So let's look at the payments that are reflected on State Exhibit 1350. First, let's look at Dr. Portnoy. And Your Honor, we've done a slide that just totals up the payments, which we could assign, with court's permission, Court Exhibit 68.
I think we're on 67, aren't we? Oh, yeah, 68. Yep, 68.
So you'll see, Dr. Kolodny, that for Dr. Portnoy, from 1998 to 2009, the total payments were $28,940. So for 12 years, the average comes out to $2,411.67. Does that math look right?
The math may look correct, but I think it's misleading to produce that figure when the total amount that Dr. Portnoy would have received from Johnson & Johnson indirectly, for example, speaking at events that were paid for by Johnson & Johnson, and the total amount they would have received from drug companies that were selling Johnson & Johnson's narcotics, I think is a much larger figure. So to produce that particular number, I think, is somewhat misleading.
My point is this, that if you have evidence you want to bring in on other payments, we'll look forward to seeing that. But in terms of these payments, the math is right, correct?
In terms of, I haven't summed it up, but I'll trust your math that the average you've calculated on this particular document is correct.
And you understand that as we're in court this morning, there's only two defendants, Johnson & Johnson and Janssen Pharmaceuticals. You understand that?
I understand that Johnson...
That's all I'm asking you, sir.
I do understand that there are two defendants whose narcotics were being sold by other drug companies.
And we'll get to the supply of narcotics and we'll talk about that, okay? So let's look at the next. Dr. Fishman, and we've done a slide, Your Honor, that will, with your permission, mark as Court Exhibit 69.
Yes.
And you'll see here just payments in 2 years, 2008, 2009. Total payments $4,898 for an average of $2,449 a year. We've done a summary as well for Dr. Fine, and with the court's permission, mark that as Court Exhibit 71.
Yes.
And you'll see for Dr. Fine,
Did you say 71?
71, I believe, Your Honor.
70.
70? 70, I apologize. And so on this, payments from 2007 to 2012, total payments $174,786 over 6 years, average per year $29,131. And then we've done a summary for Dr. Webster that we talked about as well, to his clinic, 2010, 2013, total payments $133,662 over 4 years, average $33,415 and $15.50. And would that be Exhibit 71?
Yes.
So we could ask that to be marked as Court Exhibit 71, Your Honor.
Yes.
So we also prepared a visual comparing those amounts with the amounts that Dr. Kolodny has been paid. And with the court's permission, we would show that as Court Exhibit 72.
Yes.
So we did total payments to all of the various KOLs that are listed on Exhibit S1350. And you'll see the top payment is to Dr. Panchel, $265,000. Dr. Fishman is the lowest at $4,000. But Dr. Kolodny, you would agree that the money that you've been paid as a paid expert in this case is substantially more than any of these KOLs were paid for the work they did for Johnson & Johnson, correct?
I think that your slide is misleading.
It is for the court to decide if it's misleading. So let me just ask you the facts. Isn't it true that the amount you've been paid by the state to work as a paid expert in this case is at this point easily over $500,000?
I don't know that that's true, no.
We know the amount if we had the time reference, but it's certainly by the time of your deposition, you thought it was $300,000 to $500,000, right?
At the time of my deposition, my estimate was that it was in the range of $300,000 to $500,000.
And you've testified that since then, during trial, you put 40 hours a week or more into the case, right? Right?
Yes.
And we've been here, this is the fourth week we're starting, I think, by
Yes.
my count.
Yes.
And you spent a lot of time preparing for the trial as we were heading into trial, correct?
That's correct.
Working with the state's lawyers and helping to get ready for the trial, right?
That's correct.
So isn't it a fair statement, Dr. Kolodny, that the money that you've been paid by the state as an expert is substantially more than any of the payments that are listed on State Exhibit 1350?
It's correct that I've been paid more than these individuals were paid specifically or directly from Johnson & Johnson as appears on that exhibit.
Thank you. Now we'll get to supply, okay? You have criticized Johnson & Johnson's subsidiaries for supplying raw materials and API to Purdue for their manufacture of OxyContin. And my memory is at one point you testified that at some point after 1998, Aramco should have stopped supplying API to Purdue Pharma or its affiliates, correct?
So I think, I'm not sure you characterized my testimony accurately. I have criticized Johnson & Johnson for flooding the United States with its opium and for promoting an unbranded campaign to increase prescribing and to continue doing that and to continue directly promoting its own opioids despite overwhelming evidence that the opium that was flooding into the United States from Tasmania was causing a public health crisis. That's what my criticism was focused on.
That wasn't my question. I was just asking about testimony that you gave under oath in this court. And isn't it true that you were asked this question and you gave this answer? Question. My question is it your testimony that at some point after 1998, Aramco should have stopped supplying active pharmaceutical ingredients to Purdue Pharma or one of its affiliates? Answer, yes. That was your testimony, right?
That's correct. So that if Johnson & Johnson,
Sir,
I haven't finished my answer, sir.
Your Honor, I would move to strike everything after yes. I asked him a very simple question, if that was his testimony, period.
Your Honor, based on your prior rulings, if they're going to move to strike, I think he should be allowed to finish his answer and not cut him off in the middle. I think that was what Your Honor ruled previously. This is repetitive practice.
Your Honor, we've been hearing time and time again speeches given by Dr. Kolodny in response to questions that do not ask for him to give those speeches. And I'm trying to be patient with Dr. Kolodny as best I can, but at some point, we need to finish this examination up and get straight answers to the questions that are being asked.
I'll sustain the objection. You may answer the question.
If Johnson & Johnson had been adhering to its code of business conduct, a code which I believe states that Johnson & Johnson doesn't do business with organizations that are behaving badly, that if Johnson & Johnson had been adhering, complying with its own code of business conduct, it would have stopped doing business with Purdue Pharma.
So let me ask you some questions, Dr. Kalani, and try to get through this, okay? First of all, is it true you became aware of Tasmanian alkaloids in 2012?
I think that's about right. I can't remember the exact year, but that sounds about right.
And in 2015, while you were on a trip to Tasmania, you testified you met with a former employee of Tasmanian alkaloids, correct?
That's correct.
And that was Mr. Hartnett?
That's correct.
And did you learn at the time that he was a former employee of Tasmanian alkaloids?
I was aware before I met with him that he had been the managing director. I think he ran Tasmanian alkaloids for about 30 years prior even to Johnson & Johnson purchasing it.
So he'd been there a long time?
Yes.
Had a lot of information?
Yes, he did.
And when you were in Tasmania, did you make attempts to meet with any other opioid raw material companies?
I don't recall. I think I did reach out to the head of the Poppy Growers Association, but I don't remember meeting with representatives from some of the other companies that were processing the opium.
Have you done so since then?
Have I done what since?
Have you attempted to meet with other manufacturers of the raw materials in Tasmania?
I haven't been back to Tasmania.
So have you attempted to meet with any of the other manufacturers of raw materials in Tasmania?
No.
Have you attempted to meet with any other producers of the raw material elsewhere in the world?
No.
Are you aware of Francopia in France?
Yes, somewhat vaguely familiar.
And you understand that they are a producer of raw material that's used in the manufacture of opioids?
I've heard of them. I know very little about them.
Have you made any effort to find out more about them?
No.
Are you aware of Alacaliber in Spain?
No.
Are you aware that they also are a producer of raw material that's used for the production of opioids?
I'm not familiar with them.
Are you familiar with GlaxoSmithKline, previously GlaxoWellcome?
Yes, I am.
And you understand that they are a producer of raw materials used for opioids, correct?
Yes, a major producer.
And they were mentioned prominently in that article by Dr. Fist that you talked about, right?
Yes.
And that's Exhibit State 0006. So you were aware that GSK, if I can call them that, had about an equal share of the Tasmanian poppy business, right?
Globally, but as far as the opioids that were flooding into the United States, my understanding is they were primarily coming from Johnson & Johnson, that Glaxo, their opioids were supplying other parts of the world. That was my understanding, at least.
Did you ever make any effort to meet with anyone from GlaxoSmithKline?
No, I didn't.
Are you aware that Glaxo actually introduced the poppy industry to Tasmania?
No, I understand the history a little differently.
Well, take a look at Exhibit S0006, if you would. May I approach, Your Honor?
Yes, you may.
And that's the article by Dr. Fisk. If you could take a look at page 2. See there's a history there down at the bottom of the establishment of the industry in Tasmania. And you'll see it describes that the poppy industry was introduced to Tasmania in the late 1960s by the Edinburgh-based company McFarland Smith, a subsidiary of Glaxo. See that?
I do.
Did you learn in the course of your work that GSK sold raw material to Rhodes, Purdue's API manufacturer?
I don't recall.
Did you make any effort to determine how much API GSK sold to Rhodes?
No, I didn't attempt to determine that.
Yes, I misspoke. Did you make any effort to determine how much of the raw material used for opioids GSK sold to Rhodes, Purdue's API manufacturer?
No.
Did you make any effort to meet with any other raw material or API manufacturers that produce opioids? For example, Mallinckrodt,
No.
Rhodes,
No.
Johnson Matthey,
No.
Siegfried,
No.
Cambridge,
No.
Aspen.
No.
Let's talk about the research you did on Johnson & Johnson and its subsidiaries. So the meeting you had with Mr. Hartnett was March 2015, right?
That's correct.
And in that meeting with Mr. Hartnett, did he describe to you the history of opium production in Tasmania?
Yes.
Did he describe for you the history of Tasmanian alkaloids under Johnson & Johnson's ownership?
Yes.
Did he describe to you the development of the thebaine-rich Norman poppy
Yes.
by Tasmanian alkaloids?
Yes.
And did he describe to you Johnson & Johnson's role in the opioid supply chain?
Somewhat, yes.
He did, didn't he?
I don't, that last part, I don't think we went to in depth on.
Let me hand you your declaration. I may approach your honor.
Yes, you may.
Thank you.
This is a document entitled Declaration of Dr. Andrew Watney. You'll see on page 4 there's a signature and a date. Is that signature your signature?
On the last page?
Yep, on page 4.
That's my signature.
What date did you sign this?
April 23rd, 2019.
Within the last 2 months, right?
Correct.
And this declaration was submitted by the state's lawyers in opposition to a motion to exclude some of your testimony as an expert witness. You recall that?
Correct.
And you were providing this to provide to the court what you felt were qualifications to allow you to testify as an expert, correct?
Correct.
Including regarding opioid supply by Johnson & Johnson subsidiaries, correct?
That's correct. My statement was that we didn't go into depth on their role in the supply chain, but we certainly discussed it.
Yeah, and let's see what you told the court in submitting a declaration in opposition to a motion challenging your qualifications as an expert. You take a look at page 4. And can you repeat what you said to the court in paragraph 12? And I would ask you, please don't characterize, just read.
At the meeting, Mr. Hartnett explained the history of opium production in Tasmania, the history of Tasmanian alkaloids under Johnson & Johnson's ownership, the development of the thebaine-rich Norman poppy, and Johnson & Johnson's role in the opioid supply chain.
And that was explained to you, just to be clear, in March of 2015, correct?
Correct.
If we could pull up exhibit stage 0906. This is an exhibit we've seen quite a bit, including the second page, which is the chart that Mr. Beckworth set up and went to several times during your examination. So you're familiar with this chart, correct?
I am.
And you'll see at the bottom, and we can blow it up, the sources are indicated as International Narcotics Control Board, World Health Organization, population data.
That's correct.
So you testify that the International Narcotics Control Board monitors global opioid consumption. Is that correct?
That's correct.
And do you understand that it is authorized to do so as part of its mission to regulate the worldwide legal manufacture of narcotic drugs?
That sounds correct to me.
And is it your understanding that the INCB, part of its mission is to limit the cultivation, production, manufacture, and use of drugs to an amount required for medical and scientific purposes, to ensure availability for such purposes, and to prevent illicit cultivation, production, and manufacture of, and illicit trafficking in, and use of drugs?
That sounds correct.
So are you aware that the oxycodone that is reflected on Exhibit S0906 is regulated by the United Nations through the INCB under international drug control treaties like the 1961 Single Convention on Narcotic Drugs?
So I am aware that it's regulated. It's also regulated in the United States by the DEA, but my understanding is that the quotas and the regulations are linked to medical use, so that as medical use kept going up, the way that the laws were written, the quotas had to keep increasing. And so I don't believe when those treaties were drafted, anyone could have predicted that a multifaceted campaign would be launched to encourage the medical community to prescribe aggressively. I think these treaties would have worked very well had the dam of narcotic conservatism not been destroyed. That's what these treaties were based on. They were based on an assumption that the medical community would be prescribing appropriately.
Let me try getting my question answered again, because it was really a pretty straightforward question, and that is your understanding that the INCB, as part of its mission to regulate the worldwide legal manufacture of narcotics, for this oxycodone that we're seeing on this map,
Yes.
is actually regulated by the INCB.
I understand that there is international regulation of opioid, or international monitoring of opioid consumption. I'm not familiar with the regulatory role of INCB beyond monitoring. I don't doubt you if you say that they do have a regulatory role.
So that's not something you're familiar with beyond what you said?
Correct. I know that they monitor global consumption and they put out a report on an annual basis. And so I'm familiar with that report and with data that they collect.
If I understood your prior answer, what you're basically saying, the supply that's authorized really tracks the prescriptions and the demand that's needed.
Correct.
So it's the over-prescribing really that's prompting the supply.
As the prescribing would go up, and the assumption was that that prescribing was appropriate, at least in the United States, the quota would be increased each year. So there's been a quota for every molecule, every narcotic molecule, and the quota was based on the previous year's consumption.
So I want to talk about Kingpin, okay?
Yes.
And you've mentioned the term several times. We've already covered that it is not the term that was used in your expert disclosure back in December. We've also gone over your declaration in your meeting with Mr. Hartnett, and want to ask you about the first time you actually publicly used the term in reference to Johnson & Johnson. And is it true that the first time you did so was in a tweet that you made on March 12 of this year?
I believe so. I think the first time was there was news coverage of this litigation by an outlet called Axios, a news outlet. And I believe that I tweeted their news story, and I believe that my tweet, sometimes I just tweet something, and the tweet becomes the headline of whatever you're tweeting. But I think I composed in my tweet more than that. I added a little bit of a comment, and that was the first time I recall the term kingpin reading it, and that's the first time I've used it. I think I like that term because I think it appropriately characterizes
Sir,
Johnson & Johnson's role.
It was first in a tweet. That's all I
Yes, yes.
Okay, thank you. Can we show you exhibit? I may approach, Your Honor?
Yes, you may.
I handed you what's been marked as Exhibit J0249. J2049. And is this the tweet, your tweet on March 12, 2009? I'm sorry, March 12, 2019.
This is the tweet I was just discussing.
So let's go over. Yeah, Your Honor, I move Exhibit J2049. Okay.
J2049 will be admitted to the evidence and may publish.
So Dr. Kolodny, just in terms of timing, you have your meeting with Mr. Hartnett in March of 2015. You do your expert disclosure in December of 2018. And in March 12, 2019, you tweet Kingpin, right?
That's correct.
And you tweet Kingpin because in the lawsuit, in this very lawsuit, the state's lawyers had made an accusation that Johnson & Johnson was the opioid kingpin, correct?
That's correct. I wasn't the first to apply that term.
Now, Mr. Beckworth asked about the definition, or argued or suggested to the court it just meant leader, but you were asked about what you meant by kingpin in your deposition, weren't you?
I was.
And you said that you wanted to look up the definition, but you didn't get around to it. You wanted to look up the definition of kingpin, but you didn't get around to it before your deposition, right?
I did say that, yes.
And your deposition was on March 27, 2019, correct?
I believe so.
You should have the transcript in front of you. Why don't you just refer to it and confirm that that's the date?
Did you say March 27th?
Yes.
Yes.
And that was 2 days after the settlement was announced with Purdue Pharma, wasn't it?
I believe so.
So 2 days after that settlement, you show up for the deposition and you had a whole lot to say about Kingpin, didn't you?
I think I was asked why I was referring to Johnson & Johnson as a kingpin, and I was very happy to be asked that question, yes.
And you were asked in that deposition what you understood Kingpin to mean. Do you remember that?
Yes.
And what you said in your deposition under oath was not that it was just a leader, but it was a drug dealer, an illicit drug dealer. Do you remember that?
I don't think I said that Johnson & Johnson was an illicit drug dealer. I may have said acted like an illicit drug dealer.
You said that's what a kingpin is. Do you remember that?
Yes, so I recall what I said, and I started by explaining what I thought the definition of a kingpin was, and I think I said that I believe that the definition of a kingpin is like a drug dealer who all of the other drug dealers buy their drugs from, the drug dealer at the very top. That's what I think a kingpin is. And then I went on to explain that Johnson & Johnson, in my view, had acted like a kingpin.
Can I ask my question and try to get an answer? Isn't it true that in your deposition, you testified under oath that you believe the term kingpin is used to describe illegal drug, illicit drug dealers, and kingpin is the person that all the drug dealers buy their stuff from? Wasn't that your testimony?
Yes, that my testimony was that that's what I think that's what I believe the definition in general of a kingpin is.
And you said further under oath in your deposition on March 27, 2 days after Purdue settled, that so kingpin. When I say kingpin, I mean kingpin. I mean kingpin like a drug dealer kingpin. Was your testimony?
Yes, that you're pulling out the very final part of an answer to a question. I said a lot more than that, and after explaining Johnson & Johnson's role in our opioid crisis, selling opium to a company that was doing so illegally, promoting its own opioids improperly, that it was a kingpin like a drug dealer kingpin, yes.
We're going to go with what you said under oath in your deposition, sir, okay?
Yes.
Isn't it true, the fact is that we've also looked throughout the thousands of articles, public statements, tweets, and everything else, sir, and have found no mention of kingpin, no accusation against Johnson & Johnson of being the opioid supplier who is responsible for this crisis before March 12, 2019. Okay? After you've been paid hundreds of thousands of dollars as a paid expert for the state. My question is, sir, do you believe the court should believe you when you say that hundreds of thousands of dollars that you've been paid has not influenced you in accusing Johnson & Johnson of being an illegal, illicit drug kingpin?
So prior to this litigation, I was aware of Johnson & Johnson's role in
I
it.
just asked you if that's what you want the court to believe, sir.
I'm answering your question, sir.
It should be yes or no, sir.
It's not a yes or a no question.
Then that's fine. Thank you. Pass the answer.
Your Honor, do you want me to go now or come back? Whatever.
Just go. I'll probably cut you off in about 15 or 20 minutes
Cut me off.
for break.
Well, look here, Judge. Dr. Chladni, you were asking questions about all the money you've been paid. From 2013 till late in 2017 when you and I first met, how much money did the state of Oklahoma pay you to work on the opioid crisis?
Objection. States the evidence, Your Honor.
Overruled.
I was working on a prescribing program with the state. It was, I think, funded by the federal government. I put in a few hours. I think that might have been in 2017 before the litigation, and it would have been a very small amount of money, but there might have been something prior to 2017.
But for your testimony, did the state pay you to work as an expert witness?
No.
And did you ask or did the state offer to reimburse you for the 14 plus years you spent investigating the opioid crisis and its causes or going to Tasmania or any of that kind of thing?
I think the state was interested in my help as an expert because I had that experience.
Right, did we pay you or reimburse you?
You did not.
Okay, now, Mr. Yoder asked you about State's Exhibit 3138, and that was a paper that you and Dr. Courtwright and others wrote, right?
Correct.
Okay, let's go to page 003 of that. So if you pull that up there, Mr. Medina, on the introduction there, we see this chart that, if you go down, we've seen a lot about that, right? And that's a chart that you
Yes.
used in your paper.
Yes.
Have you seen anyone else that used that chart in explaining the origins of the opioid crisis and its impact?
Yes, that exact chart was used by the CDC and published a few months before we published it. The CDC, when they published this chart, their source was the same source we used, but they included a little language mentioning that they had adapted it. We forgot to include that additional language saying that the CDC had adapted this. But yes, I didn't create this chart. CDC created it and published it a few months before we did.
Okay, and let's look where else it might have been. Do you recall looking at the court exhibit where Timothy Fong gave a speech in April of 2016?
I do.
Now, this lawsuit was filed on my birthday, June 30th, 2017. April 21st, 2016 is more than a year prior to June 30th, 2017, correct?
That's correct.
Now, let's look in this deal that Timothy Fong did. Do you see a graph that looks familiar to one that you've used and has been used in this case?
Yes, Dr. Tim Fong used the exact same graph that I used and that the CDC developed.
Okay, and that's Tim Fong again as the defendant's paid expert.
That's correct.
But this was a year before they paid him for our litigation, right? Because we hadn't even filed it.
Yes, the year before the litigation, before they started paying him, he was saying exactly the same things. Exactly the same things that I was saying.
Okay, we'll come back to Dr. Fong in a minute. Can we go to 0005 of your paper? Mr. Dina? So, Mr. Yoder was asking you, may I approach her?
Yes, you may.
A bunch of questions about some statements you made about Purdue out in the world prior to this lawsuit. Now, your paper was written in 2014, is that correct?
We started working on this paper in 2013, and I believe it was published January 2015.
Okay, so let's look at the first paragraph here. It says, in 96, the rate of opioid prescribing began accelerating rapidly. Is that a true statement?
That is a true statement.
And in 1996, was that the first time that a drug manufacturer had started aggressively marketing opioids for non-cancer pain?
That's when it began.
Okay. So, but let's look at what else was said. Can you go down to the last paragraph that begins prior to? So let's just kind of walk through this. This says, prior to the introduction of OxyContin, many physicians were reluctant to prescribe OPRs on a long-term basis for common chronic condition because of their concerns about addiction, tolerance, and physiological dependence. Was that a true statement more than 3 years prior to this lawsuit?
It was.
Did we pay you to write that statement?
No, you did not.
Did Dr. Courtwright join with you in this paper?
Yes, he did.
He described this dam of narcotic conservatism, correct?
Yes, he did.
Is this what's being referred to? One of the things about conservatism is the reluctance of doctors to prescribe OPRs for everyday pain?
Yes, we had an appropriate understanding of their risks and benefits.
Okay, and then it says, to overcome what they claim to be opiophobia, physician spokespersons for opioid manufacturers. Well, let's stop there. Does that say manufacturer or ers?
ERS.
Dr. Klodny, words matter, don't they?
They do.
Dr. Klodny, when you put an S on the end of the word, does that make it a plural?
It does.
So letters matter too, don't they?
They do.
Yeah, they do. Okay, now let's go on to opiophobia. Mr. Medina, can you pull up 1364 states? Now, opiophobia. This is a document that Drew Dieselhorse used in the state of Oklahoma. And what does it say here on page 16 about opiophobia?
Your Honor, objection beyond scope.
Your Honor, he went right through this document.
Objection is overruled.
Thank you.
It says, avoid the addiction ditch. Use Portnoy's study to create dialogue about opiophobia as a barrier.
Okay, now, did you know about Jansen's use of opiophobia here in Oklahoma and calling upon our doctors when you wrote this paper back in 2014?
We knew that the term was being used nationally, but we didn't have specific information about Johnson & Johnson doing that here in Oklahoma.
Could you have known without access to the documents that were produced in this case?
No, without the discovery, we would not have known for a fact that they were doing it here in Oklahoma.
Let's back out to this paper. Okay, so the next sentence of this says, opioid manufacturers published papers and gave lectures in which they claimed that the medical community had been confusing addiction with physical dependence. They described addiction as rare and completely distinct from so-called physical dependence, which was said to be clinically important.
Unimportant.
Unimportant. Now, you've seen the evidence in this case. Did Jansen do similar things?
Yes, they did.
Okay, and it says they cited studies with serious methodological flaws to highlight the claim that the risk of addiction was less than 1%. Now, you were talking about use of Porter and Jick, right?
That's correct.
Okay, Mr. Medina, can we go to, which exhibit was that? 1%. 0740. Now, is this an example of Jansen using the 1% Porter and Jick study in Speaker Bureau education?
Not sure if this was Speaker Bureau education, but this is an example of Johnson & Johnson and Janssen promoting deceptive misinformation about opioids.
Let's refresh your memory. Could we go to the cover page of this document? What does that say? It's Janssen Pharmaceuticals, Regional Medical Services, Medical Affair, right?
Yeah, so when you see name, comma at the top, it looks like this is a slide set that's been prepared for someone on their Speakers Bureau to add their name to it and use these slides.
Okay, great. Now let's go to the other document that Mr. Yoder used. It was the Senate testimony, America's Addiction to Opioids, Heroin, and Prescription Drug Abuse. Do we have that one? We may have to have Mrs. Janice put that up, because we didn't have that until the day started, wasn't on their quick list. Would that be possible? I'd be able to put that up. We go to page,
Your Honor, we can do that, but if we're taking a break, we can just provide him, he can do it. Just gonna have him.
well, I can
Well,
just have him read over my.
Until there's an opportunity, I'd prefer it be put up right now because we're not taking a break yet.
Page 3 of Dr. Klein's letter. No, this is the one y'all used today. Thank you. And at the end, we have page 3 towards the end. Great. We just blow up the first part here in the first half of page 3. Be awesome. The one that y'all read from Dr. Clodd in the last 6 pages of the whole document.
It's toward the end of the document. I was the last speaker.
Thank you so much. Now, if we could just maybe blow this part up, that'd be great. Thank you, ma'am. So, Dr. Claudia, let's just kind of go over that. You had your some charts here before,
Yeah.
and let's just talk about what you said here. Now, this testimony or written submission to the Senate was in May of 2014, right?
That's correct.
Did we pay you for your work doing that?
No.
Okay. Now it says, please keep in mind that the red line represents more than 125,000 lives lost from OPR overdoses over the past decades. Is that a significant loss of human life?
Yes, it is.
This is a public health crisis of catastrophic proportion. We asked you to write that.
No.
Have you and I met?
No, we hadn't.
Millions of Americans have become addicted to opioids, and thousands are dying each year from overdoses. That's still true today, isn't it?
It is.
Now, here's what I want to ask you about. Opioid-addicted individuals will struggle, and their families will struggle with this devastating disease for the rest of their lives. Dr. Claudia, is that a true statement?
It is.
Does that mean that we need to treat people, or they will continue to struggle with addiction?
It does.
Every state in the country has counties that have been affected. Is that true in Oklahoma?
It is true.
The towns hit hardest have lost an entire generation. Is that true in Oklahoma?
It's true.
For example, we heard Mr. Box talk about his son lost. That's a generation of that man's family gone forever, isn't it?
That's true. That's true.
Beyond the scope.
Sustained.
These are towns where grandparents raise grandchildren because young parents have died from an overdose, or they are in jail, or they are unfit to raise children because their addiction remains untreated. Dr. Claudia, we talked about this. Did you write this because there's a need to treat people who are addicted to opioid prescription drugs?
I did.
Okay, now let's look at what they tried to imply here. Doctors didn't start over-prescribing opioids out of malicious intent. For most of us, now us, you're a doctor, right? Yes?
Yeah, yes.
For most of us, it was a desire to treat pain more compassionately that led to over-prescribing. We were responding to an educational campaign. Now, were you in the courtroom when Jansen's representative, Kimberly Dean Eshman, testified for 4 days while I asked her questions?
I was.
Did
For
she,
much of the time, I was.
did she say, when I said you tried to influence, did she say something else?
She said education.
Okay, right here in this letter, years before she testified in this court, we see you use the word educational campaign, right?
Yes.
And again, it says funded by who?
Opioid manufacturers.
And there's an S, right?
Yes, there is.
Plurals matter, don't they, doctor?
They do.
That minimize risk, especially the risk of addiction. Did Jansen do that?
We know they did.
And exaggerated benefits of using opioids long-term for common problems. Did Johnson & Johnson and Jansen do that?
Yes, they did.
We were led to believe that the appropriate way to treat any complaint of pain was with an opioid prescription. We were badly misinformed. Did Johnson & Johnson and Jansen do that?
Yes, they did.
Thank you. Was anyone paying you from the state of Oklahoma to write this letter in May of 2014?
Nobody was paying me to do that work.
Thank you, Doctor.
Mr. Beckworth, before you move on, I think we're going to take our lunch break now.
Thank you very much.
Okay. After we sort through the exhibits that were introduced this morning, well, we'll break now, but I'll have attorneys come up. I'm going to have a status conference regarding the Teva settlement right at 1, and then shortly after, we'll just roll right back into the redirect. So just be here at 1, okay? Thank you.